Well, after the expiry of about 1 year, 9 months, a Justice Sanjay Kishan Kaul-led bench delivered the final orders in the case, which was registered in April 2019 on a suo motu basis after sexual harassment allegations were levelled on the 46th Chief Justice of India, Ranjan Gogoi. Advocate Utsav Bains had then claimed that he was in possession of material to prove that there was a larger conspiracy to destabilize the office of the Chief Justice of India. Justice Arun Mishra-led bench in April 2019 then initiated the Suo Motu proceedings and had appointed Justice A.K. Patnaik to a probe into the contents of the allegations put forward by Bains. Today, Justice Sanjay Kishan Kaul, while reading out the operative part of the order, noted that Justice Patnaik had relied on the Director of Intelligence Bureau's report, which stated that Justice Gogoi, having delivered judgments in contentious issues like NRC in Assam, etc., and other orders on the judicial side, it could not have been ruled out that the allegations put forth him could have been a result or could have been triggered by these contentious decisions. The court also noted that after a lapse of about 2 years, recovery of electronic evidence and records was not possible, and thus that this case had to be closed down. The veracity of the allegations levied by lawyer Utsav Singh Bains could not be verified completely due to the limited access of records and other collaborative material. Simultaneously, the report on the existence of conspiracy cannot be completely ruled out, said Justice Sanjay Kishan Kaul while reading the order. Supreme Court today issued notice to the Election Commission of India and the central government over a petition seeking the option of e-voting for the people who are not there in their particular voting constituency at the voting time. The petitioner, who hails from Kerala, primarily argued that students, NRIs, migrants should be allowed the facility of e-voting or postal ballot voting through the electronic medium or virtually in these times when they are not there in their particular constituencies. The Chief Justice of India was primarily of the view that the petition should be dismissed because it cannot be entertained, since a person living in London cannot claim a right to vote in his particular constituency and that the law cannot help him in this regard. However, after persuasion from Advocate Kalishwaram Raj appearing for the petitioner and a discussion with the fellow judges, the CJI decided to issue notice in the matter. The case of construction of a few overbridges in the state of West Bengal in pursuance to the Setu Bharatam project of the central government was heard by the Supreme Court bench led by Chief Justice of India S.A. Bobde. The CJI-led bench today remarked that it would lay down certain prominent guidelines to take into account while tree deforestation exercise is carried out for developmental works. It stated that the value or the compensation for such deforestation should take into account the value of the tree being cut and its probable value in the future for the kind of timber, etc. it bears. It also said that there should be a proper mechanism to see that certain trees of certain variety and certain age or maturity should not be a subject of tree felling exercise. Dr. Abhishek Manu Singhvi, appearing for the state of West Bengal, argued that there are only 306 trees which had to be felled for the construction of these overbridges, since there were increasing number of incidents on the railway tracks. However, Advocate Prashant Bhushan vehemently opposed Dr. Singhvi and stated that over 3,000 trees, as per the expert committee report, was going to be cut down for these overbridges project. The Supreme Court will now hear the matter after 2 weeks. However, it has asked the parties to suggest names of experts who can look into the specific concern of the Supreme Court, since the CJI has made it clear that he is not primarily worried only about the 6 kilometer of stretch of land which they are arguing before the court, but about the rampant development works that is happening across the country. Lastly, the bench of Justices S. Abdul Nazir and Sanjeev Khanna today continued hearing the Franklin Templeton case, where the Karnataka High Court order is in challenge, which had directed the winding up of its 6 debt schemes only by the consent of its investors by a simple majority. Senior Advocate Meenakshi Arora, appearing for a Chennai-based investors group, argued before the Supreme Court that the point of privilege needs to be clarified by Franklin Templeton and not by Senior Advocate Arora's clients. Gujarat High Court has said that forensic audit report can be shared. The Karnataka High Court said that a copy of the report can be shared once the investigation is over. We have succeeded in being entitled to a copy of the forensic audit report. Privilege is being claimed by them. We are the investors. They are the trustees. There is a fiduciary relationship which is now broken. The argument of privilege has to be made good by them, not by me. The arguments in this case are likely to continue. Well, that's all from Supreme Court today. Do stay tuned with Supreme Court today tomorrow as well. And don't forget to like and share baranbench.com.